Hello friends, welcome to Upsc Ias. So this is the part 2 of Indian Polity lecture series. Let's start with the preamble. Stay tuned. We, the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic and to secure to all its citizens justice, social, economic, and political, liberty of thought, expression, belief, faith, and worship, equality of status and of opportunity, and to promote among them all fraternity, assuring the dignity of the individual and unity and integrity of the nation. In our Constituent Assembly, this 26th day of November 1949, do hereby adopt, enact, and give to ourselves this Constitution. Preamble text to learn. We, the people of India, having solemnly resolved to constitute India into a and to secure to all its citizens, that is, justice, social, economic, and political, liberty of thought, expression, belief, faith, and worship, equality, and to promote among them all fraternity, assuring the dignity of life. In our Constituent Assembly, this 26th day of November 1949, do hereby to ourselves this Constitution. Introduction. The American Constitution was the first constitution to begin with a preamble. Many countries across the world, including India, followed this practice. The term preamble refers to the introduction or preface to the Constitution, and it contains the summary or essence of the Constitution. N.A. Palkhiwala, an eminent jurist and constitutional expert, called the preamble as the identity card of the Constitution. The preamble to the Indian Constitution is based on the Objective Resolution. This resolution was drafted and moved by Pandit Nehru and adopted by the Constituent Assembly. It has been amended by the 42nd Constitutional Amendment Act 1976. By this amendment, the following three new words were added: socialist, secular, and integrity. Ingredients of the preamble. The preamble reveals the following four ingredients or components. One, source of authority of the Constitution, that is, the people of India. Nature of Indian state, that is, a sovereign, socialist, secular, democratic, and republic polity. Objectives of the Constitution. It specifies justice, liberty, equality, and fraternity as the objectives. Date of adoption of the Constitution. It stipulates November 26, 1949 as the date. Key words in the preamble need to understand. Sovereign, socialist added during the 42nd Amendment Act in 1976, secular 42nd Amendment Act in 1976, democratic republic, justice, liberty, equality, and fraternity. Sovereign. The word sovereign implies that India is neither a dependency nor a dominion of any other nation but an independent state. There is no authority above it and it is free to conduct its own affairs, both internal and external. Being a sovereign state, India can either acquire a foreign territory or cede a part of its territory in favor of a foreign state. India's membership of United Nations organization also in no way constitutes a limitation on her sovereignty. Socialist. Even before the term was added by the 42nd Amendment in 1976, the Constitution had a socialist content in the form of certain directive principles of state policy. In other words, what was hitherto implicit in the Constitution has now been made explicit. Notably, the Indian concept of socialism is a democratic socialism and not a communistic socialism, also known as state socialism. Communistic socialism involves the nationalization of all means of production and distribution and the abolition of private property. Democratic socialism, on the other hand, holds faith in a mixed economy where both the public and private sectors coexist side by side. Democratic socialism aims to end poverty, ignorance, disease, and inequality of opportunity. Indian socialism is a blend of Marxism and Gandhism, leaning heavily towards Gandhian socialism. However, the new economic policy NEP 1991 of liberalization, privatization, and globalization, that is LPG, has diluted the socialist credentials of the Indian state. Secular. The Indian constitution embodies the positive concept of secularism, that is, all religions in our country, irrespective of their strength, have the same status and support from the state. The Supreme Court said in 1974, although the word secular state was not expressly mentioned in the Constitution, there can be no doubt that the Constitution makers wanted to establish such a state. Accordingly, Article 25 to 28, guaranteeing the fundamental right to freedom of religion, have been included in the Constitution. Democratic. A democratic polity, as stipulated in the preamble, is based on the doctrine of popular sovereignty, that is, possession of supreme power by the people. Democracy is of two types, direct and indirect. In a direct democracy, the people exercise their supreme power directly, as in the case in Switzerland. There are four devices of direct democracy, namely referendum, initiative, recall, and plebiscite. Referendum is a procedure whereby proposed legislation is referred to the electorate for settlement by their direct votes. Initiative is a method by means of which the people can propose a bill to the legislature for enactment. Recall is a method by means of which the voters can remove a representative or an officer before the expiry of his term when he fails to discharge his duties properly. Plebiscite is a method of obtaining the opinion of people on any issue of public importance. It is generally used to solve the territorial disputes. In an indirect democracy, on the other hand, the representatives elected by the people exercise the supreme power and thus carry on the government and make the laws. This type of democracy, also known as representative democracy, it is of the following two kinds: parliamentary and presidential. The Indian Constitution provides for representative parliamentary democracy, under which the executive is responsible to the legislature for all its policies and actions. The democratic character of the Indian polity can be manifested by the following: that is, universal adult franchise, periodic elections, rule of law, independence of judiciary, and absence of discrimination on certain grounds. The term democratic is used in the preamble in the broader sense, embracing not only political democracy but also social and economic democracy. Political democracy cannot last unless there lies at the base of its social democracy. What does social democracy mean? It means a way of life that can be opted to recognize the following trinity of liberty, equality, and fraternity. The principles of liberty, equality, and fraternity are not to be treated as separate items in a trinity. They form a union of trinity in the sense that to divorce one from the other is to defeat the very purpose of democracy. Liberty cannot be diverged from equality. Similarly, equality cannot be diverged from liberty, nor can liberty and equality be diverged from fraternity. Without equality, liberty will produce the supremacy of the few over the many. Equality without liberty would kill individual initiative. Republic. A democratic polity can be classified into two categories: monarchy and republic. In a monarchy, the head of the state, usually king or queen, enjoys a hereditary position, that is, he comes into office through succession like Britain. In a republic, on the other hand, the head of the state is always elected directly or indirectly for a fixed period like the USA. Therefore, the term republic in our preamble indicates that India has an elected head called the president. He is elected indirectly for a fixed period of 5 years. A republic also means two more things. One, vesting of political sovereignty in the people and not in a single individual like a king. Second, the absence of any privileged class, and hence all public offices to be opened to every citizen without any discrimination. Justice. The term justice in the preamble embraces three distinct forms: social, economic, and political. The ideal of justice, that is, social, economic, and political, has been taken from the Russian Revolution 1917. It is secured through various provisions of the fundamental rights and directive principles. Social justice. It denotes the equal treatment of all citizens without any social distinction based on caste, color, race, religion, sex, and so on. It means the absence of privileges being extended to any particular section of the society, and improvement in the conditions of backward classes like SCs, STs, and OBCs, and women. Economic justice. It denotes the non-discrimination between people on the basis of economic factors. It involves the elimination of glaring inequalities in wealth, income, and property. Political justice. It implies that all citizens should have equal political rights, equal access to all political offices, and equal voice in the government. Distributive justice. Social justice plus economic justice is equals to distributive justice. A combination of social justice and economic justice denotes what is known as distributive justice. Liberty. The term liberty means the absence of restraints on the activities of individuals. and at the same time providing opportunities for the development of individual personalities. The preamble secures to all citizens of India liberty of thought, expression, belief, faith, and worship through their fundamental rights that are enforceable in a court of law in case of violation. Liberty, as elaborated in the preamble, is very essential for the successful functioning of the Indian democratic system. However, liberty does not mean license to do what one likes. It has to be enjoyed within the limitations mentioned in the Constitution itself. In brief, the liberty conceived by the preamble or fundamental rights is not absolute but qualified. Equality. The term equality means the absence of special privileges to any section of the society and the provision of adequate opportunities for all individuals without any discrimination. The preamble secures to all citizens of India equality of status and opportunity. This provision embraces three dimensions of equality: civic, political, and economic. Civic equality. Civic equality, right to equality, Article 14 to 18 under the chapter on fundamental rights ensure the civic equality for all citizens. Political equality, there are two provisions in the Constitution that seek to achieve political equality, such as: 1. No person is to be declared ineligible for inclusion in electoral rolls on grounds of religion, race, caste, or sex, Article 325. 2. Elections to the Lok Sabha and the state assemblies to be on the basis of adult suffrage, that is Article 326. Economic equality. The directive principles of state policy, Article 39, secures to men and women equal right to an adequate means of livelihood and equal pay for equal work in order to ensure the economic equality. Fraternity. The ideals of liberty, equality, and fraternity in our preamble have been taken from French Revolution from 1789 to 1799. Fraternity means a sense of brotherhood. The Constitution promotes this feeling of fraternity by the system of single citizenship. Also, the fundamental duties, Article 51A, say that it shall be the duty of every citizen of India to promote harmony and the spirit of common brotherhood. It shall be the duty of every citizen of India to promote harmony and the spirit of common brotherhood amongst all the people of India, transcending religious, linguistic, regional, or sectional diversities. The preamble declares that fraternity has to assure of the following two things: the dignity of the individual and the unity and the integrity of the nation. The word integrity has been added to the preamble by the 42nd Constitutional Amendment 1976. Dignity of the individual. The phrase "the dignity of individual" signifies that the Constitution not only ensures material betterment and maintain a democratic setup, but that it also recognizes that the personality of every individual is sacred. This is highlighted through some of the very provisions of the fundamental rights and directive principles of the state policy, which ensure the dignity of individuals. Further, the fundamental duties, Article 51A, also protect the dignity of women. It states that it shall be the duty of every citizen of India to renounce practices derogatory to the dignity of women. Unity and integrity of the nation. The phrase "unity and integrity of the nation" embraces both the psychological and territorial dimensions of the national integration. Article 1 of the Constitution describes India as a union of states to make it clear that the states have no right to secede from the union, implying the indestructible nature of the Indian Union. It aims at overcoming hindrances to national integration like communalism, regionalism, casteism, linguism, secessionism, and so on. Fundamental duties, Article 51A, make the duty of every citizen of India to uphold and protect the sovereignty, unity, and integrity of India. Significance of the preamble. The preamble embodies the basic philosophy and fundamental values, political, moral, and religious, on which the Constitution is based. It contains the grand and noble vision of the Constituent Assembly and reflects the dreams and aspirations of the founding fathers of the Constitution. The preamble to our Constitution expresses what our ancestors had thought or dreamt so long. In fact, the preamble can be called as the horoscope of our sovereign democratic republic. In simple terms, the preamble is the most precious part of the Constitution. It is the soul of the Constitution. It is the key to the Constitution. It is a jewel set in the Constitution. It is like a proper yardstick with which one can measure the worth of the Constitution. M. Hidayatullah, the former Chief Justice of India, observed, preamble resembles the Declaration of Independence of the United States of America, but it is more than a declaration. It is the soul of our constitution which lays down the pattern of our political society. It contains a solemn resolve which nothing but a revolution can alter. Preamble a part of the Constitution. Like any other part of the Constitution, the preamble was also enacted by the Constituent Assembly, but after the rest of the Constitution was already enacted. The reason for inserting the preamble at the end was to ensure that it was in conformity with the Constitution as adopted by the Constituent Assembly. One of the controversies about the preamble is that whether it is a part of the constitution or not. Berubari Union case of 1960. In this case, the Supreme Court specifically opined that preamble is not a part of the constitution. However, the Supreme Court accorded the significance to the preamble. Supreme Court stated that the preamble shows the general purposes behind the several provisions in the constitution and is thus a key to the minds of the makers of the constitution. Further, where the terms used in any article are ambiguous or capable of more than one meaning, some assistance and interpretation may be taken from the objectives enshrined in the preamble. Kesavananda Bharati case 1973. In this case, the Supreme Court overruled its own earlier judgment and held that preamble is a part of the Constitution. Supreme Court observed that preamble is of extreme importance and the Constitution should be read and interpreted in the light of the grand and noble vision expressed in the preamble. LIC of India case 1995. Even in this case, the Supreme Court again upheld that the preamble is an integral part of the Constitution. The current opinion held by the Supreme Court that the preamble is a part of the Constitution is in consonance with the opinion of the founding fathers of the Constitution. However, two things must be noted, such as the preamble is neither a source of power to legislature nor a prohibition upon the powers of the legislature. It is non-justiciable, that is, its provisions are not enforceable in courts of law. Can the preamble be amended? Can the preamble be amended? The question as to whether the preamble can be amended under Article 368 of the Constitution arose for the first time during the historic case of Kesavananda Bharati 1973. It was urged by the petitioner that the preamble cannot be amended as it is not a part of the Constitution. The petitioner contended that the amending power in Article 368 cannot be used to destroy or damage the basic elements or the fundamental features of the Constitution which are enshrined in the preamble. The Supreme Court stated that the opinion tendered in the Berubari Union in this regard was wrong. In this way, the Supreme Court rejected its own earlier opinion. The Supreme Court held that the preamble is a part of the Constitution. Henceforth, the preamble can be amended subject to the condition that no amendment is done to the basic features. In simple words, the court held that the basic elements or the fundamental features of the Constitution, as contained in the preamble, cannot be altered by an amendment under Article 368. The preamble has been amended only once in 1976 by the 42nd Constitutional Amendment Act. By this amendment, the following three new words were added without damaging or altering the basic structure of the preamble: socialist, secular, and integrity. This amendment was held to be valid in later cases. Part 1. The Union and its territory, Article 1 to 4. Article 1. Name and the territory of the Union. 2. Admission or establishment of new states. 3. Formation of new states and alteration of the areas, boundaries, or names of existing states. 4. Laws made under Article 2 and 3 to provide for the amendment of the first and the fourth schedules and supplemental, incidental, and consequential matters. Article 1 states that India, that is Bharat, shall be a union of states. It means Indian is a union of states rather than a federation of states. This provision deals with the following two things. One, name of the country. Two, type of polity. Our country is described as union, although its constitution is federal in structure. Why not Federation of States? The phrase Union of States has been preferred to Federation of States for the following two reasons. One, the Indian Federation is not the result of an agreement among the states like the American Federation, and two, the states have no right to secede from this federation. The federation is a union because it is indestructible. The country is an integral whole and divided into different states only for the convenience of administration. The constitution contemplated changes of the territorial limits of the constituent states, and there was no guarantee about their territorial integrity. None of the constituent units of the Indian Union was sovereign and independent in the sense as the American colonies or the Swiss cantons were before they formed their federal unions. Therefore, India is rightly described as an indestructible union of destructible states. The union government can destroy the states, whereas the state governments cannot destroy the union. In the USA, on the other hand, the territory integrity or continued existence of a state is guaranteed by the Constitution. Territory of India. According to Article 1, the territory of India can be classified into three categories: territories of states, union territories, territories that may be acquired by the government of India at any time. The names of states and union territories and their territorial extent are mentioned in the first schedule of the Constitution. At present, there are 28 states and 9 union territories. This has been obviously changed. Since 1987, there are seven union territories: Delhi, Chandigarh, Andaman and Nicobar Islands, Lakshadweep, Dadra, Nagar Haveli, Daman and Diu, and Pondicherry. Two more are at Jammu and Kashmir and Ladakh. In the original constitution, there were four categories of states and territories. Part A, which included the nine erstwhile provinces of British India. Part B, comprising five princely states with legislatures. Part C, which includes five centrally administered states, and Part D, mentioning the territory of Andaman and Nicobar Islands. But since the Seventh Amendment Act 1956, all the states except for Jammu and Kashmir belong to one class, and all the constitutional provisions relating to the states apply to all of them in the same manner. However, it may be pointed out in this connection that certain special provisions applicable to the states of Maharashtra, Gujarat, Nagaland, Assam, Manipur, Andhra Pradesh, Sikkim, Arunachal Pradesh, Mizoram, and Goa override the general provisions pertaining to the states as a class. As for the administration of certain scheduled areas and tribal areas within the states, the provisions are specially listed in the fifth and sixth schedules. Reorganization of states. The grouping of the states at independence was mainly done on the basis of historical and political principles than social, cultural, or linguistic divisions. Issue of consolidation and integration needs to pay more attention to, so there was not enough time to undertake a proper reorganization of the units at the time of making the constitution. Many committees were set up to look into the issue of reorganization of states, as there was severe pressure for formation of states on the linguistic basis, and first among them was Dhar Committee. S.K. Dhar Commission. The integration of princely states with the rest of India has purely an ad hoc arrangement. There were demands from different regions, particularly South India, for reorganization of states on linguistic basis. In June 1948, Union government appointed the Linguistic Provinces Commission under the chairmanship of S.K. Dhar to examine the feasibility of this. In December 1948, Dhar Commission submitted its report and recommended the reorganization of states on the basis of administrative convenience rather than linguistic basis. JVP Committee. Dhar Committee recommendation created much resentment and led to the appointment of another Linguistic Provinces Committee. It was constituted by the Congress in December 1948 itself to examine the whole question afresh. It consisted of Jawaharlal Nehru, Vallabhbhai Patel, and Pattabi Sitaramaya, and hence was popularly known as JVP Committee. In April 1949, JVP Committee submitted its report and formally rejected language as the basis for reorganization of states. However, in October 1953, the government of India was forced to create the first linguistic state of Andhra Pradesh by separating the Telugu-speaking areas from the Madras state. After there was a prolonged popular agitation and the death of Putti Sriramalu, a staunch Gandhian, after 56 days hunger strike for the cause. The creation of Andhra state led to the intensification of the demands from other regions for creation of states on linguistic basis. This pressurized the government of India to appoint in December 1953 a three-member states reorganization commission under the chairmanship of Fazal Ali to re-examine the whole question. Fazal Ali Commission. Other two members of the commission were K. M. Panikkar and H. N. Kunzru. In September 1955, it submitted its report and broadly accepted language as the basis of reorganization of states. It clearly rejected the theory of one language, one state. It opined that the unity of India should be regarded as the primary consideration in any redrawing of the country's political units. It identified four major factors that can be taken into account in any scheme of reorganization of states: reservation, preservation and strengthening of unity and security of the country, linguistic and cultural homogeneity, financial, economic, and administrative considerations, planning and promotion of the welfare of the people in each state as well as of the nation as a whole. The Commission suggested the abolition of the four-fold classification of states under the original constitution and creation of 16 states and three centrally administered territories. The Union government accepted these recommendations with certain minor modifications. By the passage of both the 7th Constitutional Amendment Act 1956 and State Reorganization Act 1956, the distinction between Part A and Part B states was done away with and Part C states were abolished. Some of these territories were merged with adjacent states and the other were designated as Union territories. A total of 14 states and 6 union territories were created on November 1, 1956. Territory of India, Union of India. The territory of India is a wider expression than the Union of India because the Union of India includes only states, while the territory of India includes not only the states but also union territories and territories that may be acquired by the government of India at any future time. The states are the members of the federal system and share the distribution of powers with center. Union territories and acquired territories, on the other hand, are directly administered by the central government. Admission or establishment of new states. Article 2 enables Parliament to admit into the Union or establish new states on such terms as it thinks fit by law. Thus, there are two powers delegated to Parliament by Article 2, namely the power to admit into the Union new states and the power to establish new states. The first refers to the admission of states which are already in existence, while the second refers to the establishment of states which were not in existence before. Formation of or change in existing states. Article 3 authorizes the Parliament to form a new state by separation of territory from any state or by uniting two or more states or parts of states or by uniting any territory to a part of any state. To increase the area of any state, to diminish the area of any state, to alter the boundaries of any state, and to alter the name of any state. However, Article 3 lays down two conditions need to be fulfilled by the Parliament in this regard. One, a bill contemplating the above changes can be introduced in the Parliament only with the prior recommendation of the President. And two, before recommending the bill, the President has to refer the same to the state legislature concerned for expressing its views within a specified period. In case of union territory, no reference need to be made to the concerned legislature to ascertain its views, and the Parliament can itself take any action as it deems fit. Role of the states under Article 3. Therefore, the Indian Constitution authorizes the Parliament to form new states or alter the areas, boundaries, or names of the existing states without their consent. In other words, the Parliament can redraw the political map of the India according to its will. The only condition laid down in the Constitution for the making of such a law are the following. Such a bill is to refer to the concerned state legislature by the President to express their views within a specified period. The President will specify the period within which the state legislature must express its views, but he may also extend the time so specified. The President is not, however, bound by the views of the state legislature. However, in the case of Jammu and Kashmir, the consent of the state legislature is required before a bill on such alterations is introduced in Parliament. If the period specified or extended expires and still no views of the state legislature are received, the second condition laid down in the provision of Article 3 is fulfilled. Also, making a fresh reference to the state legislature is not necessary every time an amendment or the proposal contained in the bill is proposed and accepted in accordance with the rules of procedure of Parliament. A simple majority and ordinary legislative procedure are enough for Parliament to form new states or alter existing state boundaries. It may be noted that this article does not apply to the process of cessation of territory to a foreign state. Cessation of Indian territory to foreign country under Article 3. Any treaty or agreement involving ceding Indian territory to an outside authority requires a constitutional amendment to be implemented. The Supreme Court held that the power of Parliament to diminish the area of state under Article 3 does not cover the cession of Indian territory to a foreign country. Hence, Indian territory can be ceded to a foreign state only by amending the constitution under Article 368. The Ninth Constitutional Amendment Act 1960 was enacted to transfer the Berubari Union of West Bengal to Pakistan. The 100th Constitutional Amendment Act 2015 was enacted to give effect to the acquiring of certain territories by India and transfer of certain other territories to Bangladesh in pursuance of the agreement and its protocol entered into between the governments of India and Bangladesh. Under this deal, India transferred three enclaves to Bangladesh, and while Bangladesh transferred 51 enclaves to India. For these three purposes, the amendment modified the provisions relating to the territories of four states, Assam, West Bengal, Meghalaya, and Tripura, in the first schedule of the Constitution. On the other hand, the Supreme Court in 1969 ruled that the settlement of a boundary dispute between India and any another country does not require a constitutional amendment. It can be done by executive action as it does not involve cession of the Indian territory to a foreign country. Article 2 versus Article 3. Notably, Article 2 relates to the admission or establishment of new states that are not part of the Union of India. Article 3, on the other hand, relates to the formation of or changes in the existing states of the Union of India. In other words, Article 3 deals with the internal readjustment of the territories of the constituent states of the Union of India, not amendments under Article 368. The Constitution in Article 4 itself declares that laws made for admission or establishment of new states under Article 2 and the formation of new states and alteration of areas, boundaries, or names of the existing states under Article 3 are not to be considered as amendments of the Constitution under Article 368. This means that such laws can be passed by a simple majority and by the ordinary legislative process. Henceforth, Article 4 stipulates that any such law may make supplemental, incidental, or other consequential provisions and may amend the first and fourth schedules without going through the constitutional amendment process. Acquisition of foreign territory. Being a sovereign state, India can acquire foreign territories according to the modes recognized by the international law, that is, cession, following treaty, purchase, gift, lease, or plebiscite, occupation, hitherto unoccupied by a recognized ruler, conquest, or subjugation. For example, India acquired the several foreign territories such as Dadra and Nagar Haveli, Goa, Daman and Diu, Puducherry, and Sikkim since the commencement of the Constitution. Part 2. Citizenship Article 5 to 11. Article 5. Citizenship at the commencement of the Constitution. Article 6. Rights of the citizenship of certain persons who have migrated to India from Pakistan. 7. Rights of citizenship of certain migrants to Pakistan. 8. Rights of citizenship of certain persons of Indian origin residing outside India. 9. Persons voluntarily acquiring citizenship of a foreign state not to be citizens. 10. Continuance of the rights of citizenship. 11. Parliament to regulate the right of citizenship by law. Constitutional provisions for citizenship. The Constitution deals with its citizenship from Articles 5 to 11 under Part 2. However, it contains neither any permanent nor any elaborate provisions in this regard. It only identifies the persons who became citizens of India at its commencement, that is, on January 26, 1950. It does not deal with the problem of acquisition or loss of citizenship subsequent to its commencement. It empowers the Parliament to enact a law to provide for such matters and any other matter relating to citizenship. Accordingly, the Parliament has enacted the Citizenship Act 1955, which has been amended in 1957, 1960, 1985, 1986, 1992, 2003, 2005, 2015, and so on. According to the Constitution, the following four categories of persons became the citizens of India on 26 January 1950. Persons domiciled in India, Article 5. Persons migrated from Pakistan, Article 6. Persons migrated to Pakistan but later returned, Article 7. Persons of the Indian origin residing outside India, Article 8. The other constitutional provisions with respect to citizenship are as follows. No person shall be a citizen of India or be deemed to be a citizen of India if he has voluntarily acquired the citizenship of any foreign state. Article 9. Every person who is or is deemed to be a citizen of India shall continue to be such a citizen subject to the provisions of any law made by the Parliament. Article 10. Parliament shall have the power to make any provision with respect to the acquisition and termination of citizenship and all other matters relating to the citizenship. Article 11. Citizenship Act 1955. A comprehensive law dealing with citizens was passed by Parliament in 1955 in accordance with the powers vested in it by Article 11 of the Constitution. The provisions of the Act may be broadly divided into three parts: acquisition of citizenship, termination of citizenship, and supplemental provisions. Acquisition of citizenship. The Act provides the following modes of acquiring the citizenship of India: by birth, by descent, by registration, by naturalization, by incorporation of territory, special provisions as to citizenship of persons covered by the Assam Accord. By birth, every person born in India on or after 26 January 1950 but before 1st July 1987 is a citizen of India by birth irrespective of the nationality of his or her parents. Every person born in India between 1st July 1987 to 2nd December 2004 is a citizen of India, provided either of his or her parents is a citizen of India at the time of his or her birth and the other is not an illegal migrant at the time of their birth. There are two exceptions to this rule, namely children born to foreign diplomatic persons in India and children of enemy aliens whose birth occurs in a place then under occupation by the enemy. By descent, any person born outside India on or after 26 July 1950 but before 10th December 1992 is a citizen of India by descent if his or her father was a citizen of India at the time of his or her birth. A person born outside India on or after 10th December 1992 is considered a citizen of India if either of his parents is a citizen of India at the time of his or her birth. From 3rd December 2004 onwards, a person born outside India shall not be a citizen of India by descent unless his or her birth is registered at an Indian consulate within 1 year of the date of birth. By registration, the central government may on an application register as a citizen of India any person who belongs to any of the following five categories: a person of Indian origin who is ordinarily resident in India for 7 years before making an application for registration, a person of Indian origin who is ordinarily resident in any country or a place outside undivided India, a person who is married to a citizen of India and is ordinarily resident in India for 7 years before making an application for registration. Minor children of persons who are citizens of India. A person of full age and capacity whose parents are registered as citizens of India. A person of full age and capacity who or either of his or her parents was an earlier citizen of independent India and is ordinarily resident in India for 1 year immediately before making an application for registration. A person of full age and capacity who has been registered as an overseas citizen of India card holder for 5 years and who is ordinarily resident in India for 1 year before making an application for registration. All the above categories of persons must take an oath of allegiance before they are registered as citizens of India. By naturalization, the central government may on an application grant a certificate of naturalization to any person if he possesses the following qualifications. He is not a subject or citizen of any country where citizens of India are prevented from becoming subject or citizens of that country by naturalization. He is a citizen of any country. He undertakes to renounce the citizenship of that country in the event of his application for Indian citizenship being accepted. He has either in India or been in the service of a government of India or partly the one and partly the other throughout the period of 1 year immediately preceding the date of the application. During the 14 years immediately preceding the said period of 1 year, he has either resided in India or been in the service of a government in India or partly the one and partly the other for periods amounting in the aggregate to not less than 12 years. He is of good character, not being an illegal migrant. He has adequate knowledge of a language specified in the Earth Schedule to the Constitution. and in the event of a certificate of naturalization being granted to him, he intends to reside in India or to enter into or continue in service under a government in India or under an international organization of which India is a member or under a society, company or body of persons established in India. However, the government of India may waive all or any of the above conditions for naturalization in the case of a person who has rendered distinguished service to the science, philosophy, art, literature, world peace, or human progress. Every naturalized citizen must take an oath of allegiance to the Constitution of India by incorporation of territory. If any foreign territory becomes a part of India, the government of India specifies the persons who among the people of the territory shall be the citizens of India. Such persons become the citizens of India from the notified date. For example, when Pondicherry became a part of India, the government of India issued the Citizenship Pondicherry Order 1962 under the Citizenship Act 1955. Special provisions under the Assam Accord. The Citizenship Amendment Act 1985 added the following special provisions as to the citizenship of persons covered by the Assam Accord. All persons of Indian origin who came to Assam before the 1st January 1966 from Bangladesh and who have been ordinarily residents in Assam since the date of their entry into Assam. Every person of Indian origin who came to Assam on or after the 1st January 1966 but before 25th March 1971 from Bangladesh and who has been ordinarily resident in India and who has been detected to be a foreigner shall register himself. Laws of citizenship. The Citizenship Act 1955 prescribes the three ways of losing citizenship, whether acquired under the Act or prior to it under the Constitution. They are the following: renunciation, termination, and deprivation. By renunciation, if any citizen of India who is also a national of another country renounces his or her Indian citizenship through a declaration in the prescribed manner, he ceases to be an Indian citizen of registration of such declaration. When a person ceases to be a citizen of India, every minor child of that person also ceases to be a citizen of India. However, such a child may within 1 year after attaining full age becomes an Indian citizen by the established procedure to resume the Indian citizenship. By termination, when an Indian citizen voluntarily acquires the citizenship of another country, his or her Indian citizenship automatically terminates. Here, voluntary implies consciously, knowingly, and without duress, undue influence, or compulsion. This provision, however, does not apply during a war in which India is engaged. By deprivation, it is a compulsory termination of Indian citizenship by the central government if the citizen has obtained citizenship by fraud, the citizen has shown disloyalty to the Constitution of India, if the citizen has unlawfully traded or communicated with the enemy during a war, if the citizen has within 5 years after registration or naturalization been imprisoned in any country for 2 years, if the citizen has been ordinarily resident out of India for 7 years continuously. But this power of the government may not be used in the case of every citizen. It applies only to those who acquired Indian citizenship by naturalization or by virtue only of Clause C of Article 5 of the Constitution or by registration. Single citizenship. The most important aspect of the constitutional provisions dealing with citizenship is that it has established a unified or single citizen system of citizenship law for the whole country. The citizens in India owe allegiance only to the Union. There is no separate state citizenship. A citizen of India is accepted legally as a citizen in every part of the territory of India with almost all the benefits and privileges that attend such a status. This is in striking contrast to the system of double citizenship that prevails in some federal states like USA and Switzerland. Benefit of single citizenship. Before the commencement of the Constitution, there were two broad divisions among Indian citizens: British Indian subjects and state subjects. The abolition of such distinctions made the essential unity of the nation a reality. The single citizenship for the entire country removes much of the artificial state barriers that prevailed in pre-independence days and facilitates the freedom of trade and commerce throughout the territory of India. Limitations to the privileges of single citizenship in India. In India, all citizens, irrespective of the state in which they are born or reside, enjoy the same political and civil rights of citizenship without any discrimination. However, this general rule of the absence of discrimination is subject to some exceptions, such as under Article 19, the freedom of movement and residence is subjected to the protection of interest of any scheduled tribe. In other words, the right of outsiders to enter, reside, and settle in tribal areas is restricted. Any state can provide special benefits or give preference to its residents in matters that do not come within the purview of the rights given by the Constitution to the Indian citizens as under Article 15. Prohibits the discrimination against any citizen on grounds of religion, race, caste, sex, or place of birth, and not on the ground of residence. For example, a state may offer concession in fees for education to its residents. Under Article 16, the Parliament can prescribe residence within a state or union territory as a condition for certain employment or appointments in that state or union territory or local authority or other authority within that state or union territory. In the case of Jammu and Kashmir, the state legislature is empowered to define the persons who are permanent residents of the state and confer any special rights and privileges in matters of employment under the state government, acquisition of immovable property in the state, settlement in the state, and scholarships and such other forms of aid provided by the state government. Problems in dual citizenship. In the case of dual citizenship like the USA, each person owes allegiance to both nation and state and enjoys dual sets of rights, one set conferred by the national government and another by the state government. This system creates the problem of discrimination, that is, a state may discriminate in favor of its citizens in matters like right to vote, right to hold public offices, right to practice professions, and so on. This problem is avoided in the system of single citizenship prevalent in India. Overseas citizenship of India. In September 2000, the Government of India Ministry of External Affairs had set up a high-level committee on the Indian diaspora under the chairmanship of L.M. Singhvi. It recommended the amendment of the Citizenship Act 1955 to provide for the grant of dual citizenship to the persons of Indian origin belonging to certain specified countries. Accordingly, the Citizenship Amendment Act 2003 made provision for the acquisition of overseas citizenship of India (OICs) by the persons of Indian origin of 16 specified countries other than Pakistan and Bangladesh. Later on, the Citizenship Amendment Act 2015 has modified the provisions pertaining to the overseas citizens in India in the Principal Act. It has introduced a new scheme called Overseas Citizenship of India card holder by merging the Persons of Indian Origin card scheme and the OCI card scheme. Both the schemes were running in parallel. This was causing unnecessary confusion in the minds of applicants. Keeping in view some problems being faced by applicants and to provide enhanced facilities to them, above said amendments was made. POI, NRI, and OCI. Persons of Indian origin, POI. A person who or whose any of ancestors was an Indian or national and who is presently holding another country's citizenship or nationality, that is, he or she is holding a foreign passport. No specific benefits are provided to persons of Indian origin. They are eligible to only the activity as per the type of visa obtained by the Government of India. NRIs. An Indian citizen who is ordinarily residing outside India, they hold Indian passport. All benefits as available to Indian citizens subject to notifications issued by the government from time to time. All activities can be undertaken in India. They do not require a visa to visit India. Overseas Citizen of India (OCI) cardholder. A person registered as Overseas Citizen of India cardholder under the Citizenship Act 1955. They can visit India without a visa for a long lifelong. It also must be noted that OCI is not actually dual citizenships, as the Indian Constitution forbids dual citizenship or dual nationality under Article 9. DPSPs, that is, Directed Principles of State Policy, denotes the ideals that the state should keep in mind while formulating policies and enacting laws. The constitutional instructions or recommendations to the states. These are the instrument of instructions enumerated in the Government of India Act of 1935. They aim at realizing the high ideals of justice, liberty, equality, and fraternity as outlined in the preamble to the Constitution. They embody the concept of welfare state, economic and social democracy, non-justiciable in nature, not legally enforceable by the courts. Help the courts in examining and determining the constitutional validity of law. Article 36, the term state in Part 4 has the same meaning as in Part 3, dealing with fundamental rights. Legislative and executive organs of the central and the state governments, all local authorities, and all other public authorities in the country are included. Article 38. State to secure a social order for the promotion of welfare of the people. 1. A social order in which justice, social, economic, and political shall inform all the institutions of the national life. 2. To minimize the inequalities in income, endeavor to eliminate inequalities in status, facilities, and opportunities, not only amongst individuals but also amongst groups of people residing in different areas or engaged in different vocations. Article 39. Right to an adequate means of livelihood, ownership, and control of the material resources of the community. Operation of the economic system does not result in the concentration of wealth and means of production to the common detriment, that there is equal pay for equal work for both men and women, that the health and the strength of workers, men and women, and the tender age of children are not abused, that children are given opportunities and facilities to develop in a healthy manner and conditions of freedom and dignity, and that childhood and youth are protected against the exploitation and against moral and material abandonments. Article 39A, Equal Justice and Free Legal Aid. Article 40, Organization of Village Panchayats. Article 41, right to work, to education, and to public assistance in cases of unemployment, old age, sickness, and disablement, and in other cases of undeserved want. Article 42, provision for just and humane conditions of work and maternity relief. Article 43, the state shall endeavor to secure by suitable legislation or economic organization or any other way a living wage, to promote cottage industries on individual or cooperative basis in rural areas. Article 43A and B, workers in management of industries and cooperative societies. Article 44 and 45, Uniform Civil Code throughout the territory of India. Article 44 in no way infringes the freedom of religion guaranteed by Article 25. Provision for early childhood care and education to children below the age of 6 years. Article 46, promotion of educational and economic interest of scheduled castes, scheduled tribes, and other weaker sections. Article 47, duty of the state to raise the level of the nutrition and the standard of the living and to improve the public health, raising of the level of nutrition and the standard of living. Prohibition of the consumption except for medicinal purposes of intoxicating drinks and of drugs which are injurious to health. Article 48 and 48A, organization of agriculture and animal husbandry, protection and improvement of environment and safeguarding of the forest and the wildlife. Article 49 and 50, protection of the monuments and places and objects of national importance, separation of judiciary from executive. Article 51, promote international peace and security, maintain just and honorable relations between nations, foster respect for international law and treaty obligations, encourage settlement of disputes by arbitration. Classification of DPSPs. The Constitution does not contain any classification of directive principles. However, on the basis of their content and direction, they can be classified into three broad categories, namely socialist, Gandhian, and liberal intellectual. Socialist principles. Framework of a democratic socialist state. Gandhian principles. Program of reconstruction enunciated by Gandhi during the national movement. In order to fulfill the dreams of Gandhi, some of his ideas were included as directive principles. Liberal intellectual principles included in this category represent the ideology of liberalism. Socialist principles are Article 38, 39, 39A, 41, 42, 43, 43A, and 47. Gandhian principles are Article 40, 43, 43B, 46, 47, and 48. Liberal intellectual principles are Article 44, 45, 48, 48A, 49, 50, and 51. Amendments in the DPSPs. 42nd Amendment Act of 1976 added four new DPs, that is, Directive Principles. Article 39 to secure the opportunities for healthy development of children. Article 39A to promote equal justice and provide free legal aid to the poor. Article 43A to take steps to secure the participation of workers in the management of industries. Article 48A to protect and improve the environment and to safeguard forests and wildlife. 44th Amendment Act of 1978 added one more directive principle which requires the state to minimize inequalities in income, status, facilities, and opportunities. Article 38. 86th Amendment Act of 2002. This amendment changed the subject matter of Article 45 and made elementary education a fundamental right under Article 21A. The amended directive requires the state to provide early childhood care education for all children until they complete the age of 6 years. 97th Amendment Act of 2011. This amendment added a new directive principle relating to the cooperative societies, Article 43B. It required the state to promote voluntary formation, autonomous functioning, democratic control, and professional management of the cooperative societies. Why they are non-justiciable and legally not enforceable. The framers of the Constitution made the directive principles non-justiciable and legally non-enforceable because country did not possess sufficient financial resources. Presence of vast diversity and backwardness in the country. Newly born independent Indian state with its many preoccupations might be crushed under the burden unless it was free to decide. Part 4. Article 51A Fundamental Duties. Swaran Singh Committee 1976. In 1976, the Congress Party set up the Sardar Swaran Singh Committee to make the recommendations about the fundamental duties, the need and necessity of which was felt during the operation of the internal emergency 1975 to 1977. The committee recommended the inclusion of a separate chapter on the fundamental duties in the Constitution. It stressed that the citizens should become conscious that in addition to the enjoyment of rights, they also have certain duties to perform as well. 42nd Constitutional Amendment Act in 1976. The Congress government at center accepted these recommendations and enacted the 42nd Constitutional Amendment Act in 1976. This amendment added a new part, namely Part 4A to the Constitution. This new part consists of only one article, that is Article 51A, which for the first time specified a code of 10 fundamental duties of the citizens. Article 51A. It shall be the duty of every citizen of India, national flag and national anthem respect noble ideas which inspired our national struggle for freedom, sovereignty, unity, and integrity of India, defend the country, promote harmony and the spirit of common brotherhood, dignity of women, to value and preserve the rich heritage of our composite culture, natural environment, improving and protection, scientific temper, humanism, and the spirit of inquiry and reform, to safeguard the public property and to abjure the violence, to strive towards excellence in all spheres of individual and collective activity so that the nation constantly rises to higher levels of endeavor and achievement, to provide opportunities for education to his child or as the case may be, ward between the age of 6 and 14 years. The last duty was added by the 86th Constitutional Amendment Act 2002. Features of fundamental duties. Unlike some of the fundamental rights, fundamental duties are confined to citizens only. Like the directive principles, they are not justiciable, not provide for their direct enforcement by the courts. There is not legal sanction against their violation. The parliament is free to enforce them by suitable legislation. Verma Committee of 1999. The Verma Committee on the Fundamental Duties of Citizens 1999 identified the existence of legal provisions for the implementation of some of the fundamental duties. They are mentioned below. 1. The Prevention of Insults to National Honor Act 1971. 2. The Protection of Civil Rights Act 1955. 3. The Indian Penal Code. 4. The Unlawful Activities Prevention Act of 1967. 5. The Wildlife Protection Act of 1972. 6. The Forest Conservation Act of 1980. 7. The various criminal laws in force.